right. Here we go. Kyle Herbert and Peter Taff here to discuss news of the day, a little deeper dive than you may see. So, Kyle, I wanted to open up this week's episode with since this is the Dirty Verdict, to talk about some recent notable verdicts in the state of Texas.
That sounds great, Peter. Let's do that.
All right. The first one that I saw, and we may not, since we're in Houston and everything's kind of geographical, there was a $375 million verdict in Dallas. The plaintiff was the estate and family members of an elderly woman who was killed by an off-duty cable company employee. I don't want to say, I think I know who it is, but I'll probably get sued if I say it wrong, but it was one of the major ones.
It's Comcast, right?
I wanted to say it was Spectrum, which is actually my cable company, and they're very good.
So my only thought would be is if you want to have your horrible homicide-related death delayed a week or two, probably Comcast is the way to go.
Yeah, between 1 and 5 you can pick, or maybe.
It's a situation where it's not on them, it's on you to kind of schedule that stuff.
Yeah.
But if they don't show up, you probably aren't going to end up dead. So
that's true. I mean, that's I like the way, Kyle, that you look at the positives on every negative situation in life.
Give me the facts of this verdict.
This
sounds crazy.
We deviate a little bit. So the unfortunate victim, was at her home. Okay. One of this unspecified cable company personnel came by for a service call, obviously between the hours of either 1 and 5 or 8 and 12, and came back the next day, robbed her, killed her. And so the plaintiffs, obviously very good plaintiffs lawyers, put together a case of negligent hiring, probably some supervision, probably some retention. I don't know the details on what his background check showed, but obviously you had a very sympathetic victim. You had a death. So I've got some of my thoughts on it, but Kyle, what is your takeaway from just hearing this for probably the first time?
Yeah, so my initial thought is to thread the needle on a case like that, and you, Peter, you know this, you got to have just the right set of facts, right? Like, this guy, more than likely, if they're going to keep this verdict on appeal, has probably acted like a lunatic in the past. All the cases that you see, which are getting close to intentional torts, which murder is clearly an intentional tort. If you've got a supervisory situation with a company, you're looking at a situation where there previously had been reports of this crazy behavior, or that his criminal background was so obvious, and then maybe they just didn't do a criminal background check at all. I recall, 25 years ago when I was in law school, I think there's a case out there that's about like a traveling vacuum salesman who did the same thing, but this is like back in the 40s or 50s. But I'm kind of dying to know what the operative facts are, if you know them, about kind of some of the details of how they got this. First of all, a positive finding from a jury on the negligence issue. And then, the damages probably aren't that crazy. I mean, a dead person who was murdered, $375 million, is not, in fact, a wild judgment. But I'm kind of more curious about how they made out the negligence case.
Well, from what I could tell, I didn't see the news stories were a little light on that, but it was background check kind of stuff. So, and I'm guessing the damages, I did not see a lot of details about her death, but I assume she had quite a bit of conscious pain and suffering before she died for that level of verdict.
I mean, I'm assuming there's a violent and bad death.
Mm-hmm. So here are my takeaways as a kind of mediator perspective and former plaintiff's lawyer. One, when you have a death, that is a very hard way to assess for let's say a defense attorney in an insurance company, how to assess what a jury's going to do. Because I don't know how you can argue that, you just got some jury real ramped up and emotional over a low back. It was really about reptile or whatever. I mean, an elderly woman who I imagine had a very, great family who loved her. That is a very dangerous situation. I don't care what the liability is. Facts. One. Two, I think just for the general public is we assume that big companies like are run really well and very, like they have these robust background checks and all that. And for the most part they are, but they're also run by human beings that make mistakes and, maybe game the system. There may have been a manager who had a quota to hire a certain amount of people and got a bonus if he hired 10 technicians that month. And this guy was number 10 and he was on the line and the guy maybe forgot to, maybe threw some of the background check stuff in the trash.
So here's a question I have that you may not know the answer to. Every time I've had a cable guy come out to do something in my house, back a few years ago, it seemed like they were all independent contractors. And I recall getting like a text like, Johnny Instruction Installer does not work for us. I'd be curious. I mean, I'm assuming this guy was a direct employee.
I believe so.
Yeah. I mean, so that makes your case a whole lot better as a plaintiff's lawyer to not have to prove up, whether or not he was an independent contractor as opposed to a direct employee. But it's a pretty crazy case. I'm assuming it's up on appeal.
It just happened. So, yes, I'm sure it will be appealed. I mean, it could have been settled. I'll check. You never know. One benefit we have in Houston is we've got access to the really good, you can look at the dockets and see everything that's going on in a case. And Dallas, I don't think it's as good as our clerk here has. But
it's almost like they don't do anything in Dallas quite as well as it was done in Austin.
That's what,
in Houston.
Yeah. That's what people from Houston would say.
Yeah.
I'm from Houston.
Fair enough.
But yeah, those were my takeaways on it. I think, I just had a mediated case this morning, similar situation, fortunately not a death, but an assault. And I really do believe that the company was well run. It was a smaller company, but the owner was present at the mediation. I believe it was well run. I just think people have been very shorthanded. And sometimes it's like, well, maybe this isn't the most perfect person in the world, but it's better than no person, and so they just justify that, and then things happen. And
so I had a different case, but it involved a false imprisonment and fraud that had to do with a car dealership. And it's kind of a long story, but the lawyers in that case that were defending that case pounded up and down about this idea that there's some sort of a cap on or immunity for businesses when one of their employees engages in a criminal act. What is that about?
No, they'll say that's outside the course and scope of employment. And so therefore it's not their responsibility because it's the whole respondeat superior, which is you're responsible for that. The typical way around that is to just allege a lot of negligent hiring, management, retention,
hiring, training, entrustment, all that.
Yeah. That's the way around that. And that's how you, one, hopefully get to a jury if you're the plaintiff, and two, if you're the defendant, you hope they make those allegations so that your insurance company will defend and indemnify you for that.
Yeah, not drop you in the grease.
Yeah. All right. Well, I think we've covered that one. Let's move on to the next topic. All right. So we talked at length before about a very large plaintiff verdict, but the next one is a defense verdict. The case was in Nueces County, which is Corpus Christi. A commercial truck driver, which I assume would be an 18-wheeler or something large, fell asleep, struck a passenger vehicle, I believe head on, which is probably natural considering a falling asleep deal. Plaintiff had shoulder and back surgery, recommendations for additional surgery, assumed a back, neck, etc. The plaintiffs asked for $45 million, which consisted of $15 million in actual damages, $30 million in punitives. The report I saw was from the defense lawyer. Of course, most plaintiff lawyers would not go on social media and talk about how they lost a big trial. So this is from the defense lawyer. But according to that reporting, The plaintiff lawyer really played the reptile card and tried to make the jurors, fear for their own personal health and safety if they let this company continue to operate and not be sent a very, very clear message in a way that met the rules our Supreme Court sets out on how you can argue to the jury. The jury, and I'll tell you why, according to the defense lawyer, the jury found liability on the defendant, but awarded zero damages.
What?
Yes, and there's more. Wait, Kyle, there's more.
Tell me the rest of the story, Peter.
The defense lawyer stipulated to liability and recommended the jury award $250,000 in damages for what I assume were probably his medical
past meds.
Yeah.
Okay.
And took the position that yes, this was bad, but this happens. These drivers, they told their liability story the way they wanted to.
Got it.
I'm sure it entailed these guys are working hard. No one knew this was going to happen. There was no evidence.
We didn't mean to hurt anybody.
Yeah, we didn't mean it, but yeah, he fell asleep. So we'll take responsibility, find us liable, award them their medicals. We're so sorry. Move on down the road. Well, the jury awarded zero in medicals, and I believe that is the defense lawyers would say that is attributed to the fact that they felt like the plaintiff's lawyers were asking for too much money, and they were being greedy, and they weren't going to give a windfall. So, All right, I have some thoughts on that. Kyle, what are your immediate responses?
I mean, my immediate responses are kind of twofold. Number one, for our folks at home, so the reptile idea is the idea that you argue to the jury that they are setting a standard in their community by delivering a verdict that puts commercial defendants on notice that they need to be more careful in that community, right? And so a lot of times the argument is something akin to this 18-wheeler goes up and down your street 25 times a day. If you return to the judge a big verdict, it's going to tell those companies to be more careful, right? But obviously, sometimes you shoot for the moon, like you end up not getting there, right? And like anything else, if your argument strains credulity, the jury will punish you for that. So you ask for $1 million when your client's meds are $10 or $15 or $20,000. Then a jury starts to think that maybe something fishy's going on, right? They want to know how long has the lawyer been involved? Is this really a frivolous lawsuit? So let's face it, we've had enough tort reform talk in this state for the last 25 years that every juror walks into the courtroom wondering when they're going to hear the story of some frivolous lawsuit. That's their expectation, I think. And so without knowing specific facts of the case, it still stuns me that they would award nothing in damages unless the defendants, so there's a lot of factors here, right? The defendants could have agreed to stipulate to liability the morning of the trial, right? And maybe the judge decided not to let in the facts of how the accident happened because they stipulated to liability. Maybe this guy had been a repeat offender. Maybe he's been a repeat sleeper. But the judge ruled, that's not really admissible because they've stipulated liability. I don't know. Those are all real weird questions. We had a case, my firm did a few years ago, that had nothing to do with personal injury. It was a commercial case where same thing happened. Jury found liability, but zero damages. And this was a case where we were seeking not $1 million, but several $100,000. And the lawyers on the other side did not stipulate to liability. And our concern about that case was that both plaintiff and defendant were equally unlikable. Our client was a goofball. He couldn't really get his story straight. He had a very strong accent. But the other side was exactly the same. We had audio of her lying. Like she said one thing on a recorded statement and the exact opposite at trial. She also spoke with a very thick accent, made it hard to understand. And so we were concerned, and rightly so, because this is what ended up happening, was that the jury just split the baby. They gave 100% liability to the defendant, which meant that we won our case in all regards. And then the damages that they awarded were absolutely nothing. They didn't even give us our filing fees. We ended up appealing that case, basically arguing that unobjected to expert or damaged testimony has to be accepted as true by the court. We were dealing with some very peculiar lawyers on the other side of that case who didn't hire an expert, who did nothing to refute our damage model, and who did not object a single time to either our direct of our expert or our direct of our client. And in fact, their cross-examination of both of those witnesses did nothing to question their math or their truthfulness or their veracity. And so the Court of Appeals ended up awarding us several $100,000 because there's this principle at law that if you don't put something up to refute it, even if the jury says zero, you still get those. So I'd love to hear more about this case.
Okay, well, yeah, there's one other thing, and this may answer your question, and this is, again, reported by the defense lawyer, is that they did spend a lot of time in discovery and then at trial looking into the payment arrangements with the treating physicians for the plaintiff, which were done on a letter protection basis. So they spent a lot of energy, time, money figuring out how much they charge insurance companies, how much they charge Medicare, how many of this particular plaintiff's firm refers to them, what they pay when they have done reductions in the past.
Yeah.
What they did, and this is what I think plaintiff lawyers should be concerned about because there's been new laws passed, and both at the legislature and then case law, is turning a case from a plaintiff's injuries and how they've suffered to a case about what is going on between plaintiff lawyers and doctors. And it sounds like this defense lawyer did a very good job of shifting it to that, which would explain the zero damage verdict to me.
So I've got a couple of thoughts on that. Number one is juries universally are sympathetic to people like themselves, which are usually the parties, the plaintiff and the defendant, right? And nobody wants to be a tattletale, right? Like nobody wants to really stick their neighbor with the sharp end of justice. And so a normal, average, sympathetic human being is going to appear to a jury pretty sympathetic. Mm-hmm. I tell my associates and young lawyers this all the time. If you can make your case about two things, then you can win. The first thing is, if you can make your case about how your client has been seriously injured, if they have in fact been seriously injured, and combine that with a story about how the defendant's lawyers or the defendant's experts are a bunch of dirtbags, you're going to win. Give them somebody to hate, and they'll latch onto it. But that cuts the other way, too, right? Mm-hmm. If you are a plaintiff's lawyer and you are bringing in a bunch of doctors whose payment is contingent upon the success of that lawsuit, and you don't give a good narrative explanation about why that happened, you're asking a jury to really drop the hammer on you. And there are lots of good reasons, by the way, that lots of people need to be treated on an LOP. I've been to a doctor after a car accident, and my GP, who I've been going to for 20 years, says, "Oh, geez, is this related to a car accident? Because we don't help people like that."
True.
I've been right, and I've had clients who filed claims with their own insurance, and their own insurance has said, "We're not the primary payer. You need to go and seek compensation from a third party to cover these bills." And that's the reality. And if you can't present that to a jury as what happened, it really sounds like you're running a scam. And you've made the lawsuit more about you and you, as a lawyer, and you've made the case more about the doctors that treated your client as opposed to how your client's been injured. And that's a recipe for disaster. With this caveat, who knows how this case was tried? I wasn't there, and I don't want to suggest that this lawyer who handled this case didn't do a great job or didn't recognize those issues. But I would say this: if you're in that situation, as a last resort, non-suit the meds. Don't even argue them. And, I'm sure the lawyers that handled this were plenty savvy in that regard. But defense lawyers are pretty bright. They're every now and again they come up with a good trick, and it sounds like they found a good one in this case.
Well, I talked to the defense lawyer about it, and I talked about really because they're all that I see, at least in mediations, they all challenge this medical concept, and they make clear that if the plaintiff's seeking enough money, then they've got green light to go discover that and spend the money going after that information. But mostly that's pretty standard. What he did, which was impressive to me, was admit liability and really embrace it and explain it. So he got to tell the liability story on his terms, which is, it's not particularly effective to say, it's not my fault, it's not our fault, it's their fault, it's someone else's fault, it's the plaintiff's fault. But if it is our fault, then award blah, blah, blah.
You're right. 100%.
So he embraced it and said, yeah, we made mistakes here. And I think that's unique. I think it's because this person is very well respected and has the cachet with his clients.
To convince a carrier to do that.
Yeah,
it's very risky.
Yeah.
Because if you screw that up, your adjuster is about to get hosed.
Yeah. And the other thing he said is, which I thought was interesting, this is what he said first. He said, we told the jury, we're not going to try this case like lawyers. We're going to try it like regular people. And so, well, I know, but that's what he did. He basically was like,
he said, I'm not an evil lawyer robot that works for an insurance company. I'm a normal human just like you.
He did.
Did he take his lizard skin off and pull his robot eyes out so they could see that he was a normal human?
He went caveman.
Okay.
And we'll do a splice in maybe if we can get our tech together. But no, I think he just said, because a lawyer would say, we didn't do it. But if we did, then they did it. But if that didn't happen, then it was their fault. That's what lawyers do.
Sure.
At least that's a perception of what lawyers do. And so he skipped through that. So particularly if you have a lawyer that is likable, and then you have a client that's likable. And that came up today, the same case I was telling you about with the employee. The defense lawyer is likable, and the client rep was likable. So that's how what I'm hearing from, I've definitely heard about Reptile for a long time from the plaintiff lawyers. We didn't, that wasn't, at least from my deal when I got out of the business, but defense lawyers are figuring out a response to it. And it comes with like being a normal human being and not being a lawyer, and really not serving your client's head up on a platter so that someone like Kyle can go just
slice it right off.
Yeah.
So I would kind of sum it up like this. If I had good advice to give to a defense lawyer in a situation where you know that there's huge exposure, like in a really serious 18-wheeler commercial case, if you can go in front of a jury and with a straight face say, this was our fault, it's our responsibility, but he's not hurt, and you can say, we've been saying that since the outset of this lawsuit, that's great, right? It really can build the jury's confidence with you. Where they screw it up, and where I would pounce on it as a plaintiff's lawyer, is I would say, they come before you now pretending to be reasonable. This case was filed 3 years ago, and now they're here to say they're sorry, but it was my fault. If I'm a plaintiff's lawyer, I am pounding on that all day long. They're coming to you not with clean hands to explain this was their fault. It's nonsense. If they really felt that way, they should have been saying that 3 years ago.
Yeah. Kind of inside baseball question. And you may not know the answer. I don't know it, which is why I'm asking. if that were the case and you had pleadings where they'd filed motions
Those
for summary
pleadings are
judgment,
coming in. Absolutely. Those are coming in.
all right. So if they had filed a motion for summary judgment for non-lawyers,
Absolutely.
you're asking the judge to dismiss the case before it goes to a jury.
And I think there's good case law on that that's fairly recent
Okay.
that says old pleadings, though superseded, are still admissible to argue things like what we're talking about.
Yeah.
They're not really arguing, saying that they're really and truly sorry. They're making it up to inure some sense of mercy from the court and the jury when they don't really mean it.
And probably a skilled plaintiff lawyer would have anticipated this at the beginning and gotten deposition testimony where they said they got out of the defendant explaining all the ways they're not at fault, they think, right?
So when I depose a defendant, my very first question, was this your fault? Tell me all the reasons why. Tell me all the reasons why not. And then my follow-up question is those exact same two questions until they stop talking. So that in case a lawyer pulls a lawyer trick, which is really just code for good lawyering, and shows up there and changes the story, changes the narrative, then I can put that witness on the stand and say, look, you're paying a lawyer a lot of money to tell a good version of this story. But you'd agree with me when you and I sat down in my office 2.5 years ago and I asked you all the reasons why this wasn't your fault. You came up with 13 different reasons why. And that's why you didn't resolve this case before now. Fair enough? And, like that defense lawyer said, I'm going to talk to you like a normal human being. I try to talk to witnesses like a normal human being. Tell me all the reasons why this jury shouldn't think this is your fault. And they give me all the reasons. And then if they come back later and say, oh, geez, my bad, well, then I get to call that person a liar. And that's
the L word.
And that is literally the most powerful thing you can do. You can leave damages to the side. You can leave tactics to the side. You can leave the reptile to the side. If you can make a witness who is important to the case, the plaintiff or the defendant, or a vital expert, seem as though they are a liar, and even worse, a liar for money, you win your case. And that was going to be my second point. I said best practices for defense lawyers was to, if you're going to admit liability, do it early and do it often. What I would say for plaintiff's lawyers is once you identify the liar, not lawyer, liar, important distinction. Once you identify the liar on the other side for the defendant, make that person your star witness. And if that's an expert, don't get him struck. If someone is, so there's two sides to this coin, right? Plaintiffs, we bring the doctors that have treated our client live. The other side brings their doctors that have examined him. If you catch one of those doctors in a lie or make it seem as though he's getting paid to give testimony, which they are, you don't strike that guy. You cross-designate him. You call him first, you call him second, you call him last, you cross him, you talk about him in closing. I mean, dear God and baby Jesus, he's in the courtroom when you give closing, and you can point to him, and you can say, they want to tell you now they sure are sorry, but they paid this dirtbag $25,000 to lie for you. Let's put their money where their mouth is. Do they really, really want your sympathy, or are they willing to pay anything to get out of being responsible? So that's the way I approach situations like that, and I've been pretty successful at it, but you never know. In the heat of battle, in the heat of trial, you never know what's coming next.
Very good. Well, I think we've got that one covered, so we'll move on to our next topic. All right, so this story was a couple months ago, and I think it even got to the Chronicles.
Lay it on me.
Chronicle is very good about clickbait, and so this is very clickbaity. All right, so Geico was ordered to pay a woman, I don't have the number, but I believe it was 7 figures, paid a woman who contracted HPV after having sex in a car.
Mm-hmm.
And the Geico argued, well, so why does Geico have anything to do with that question, right?
Right.
Because
that's my first question.
Because the owner of the car, the man who, I guess, a judge or jury found past the HPV, but he had insurance that operating the vehicle, and I don't know if it was operating,
let me stop right now.
yeah,
Peter, is this a long way of you telling us that Geico is your carrier?
no, no.
All right, so this she's in a car insured by Geico, and she contracts HPV.
And it's kind of a complicated procedural process, but the end
result...
result...
I've been through that procedure before.
Yeah, the end result is Geico was found to be on the hook to cover her damages under this gentleman's policy. So
this was a consensual act in a vehicle.
Yes.
Covered by Geico.
Right.
And she's saying that this gentleman, if we could use that term loosely, did not disclose that he may or may not have had a social disease, and she ended up contracting it.
Yes.
Love it.
And so I guess the language of the policy said it would cover claims against this guy for bodily injuries arising out of the ownership, maintenance, or use of the auto. And so I assume...
I mean, it sounds like they both got a fair amount of use out of that vehicle.
Yeah. And someone was, we got to be careful. I got to be careful in 2022 about some of the word choice. But so my takeaways before I come to you. So if, and this is for lay people and also for people that represent individuals or get a phone call like a lot of lawyers do from their friends or their family, don't know what to do, or if you have a company, that's got an insurance broker. If a claim is filed against you, don't just assume that you don't have insurance for it. Ask your agent, give it to your agent, ask them whatever policies I have, see if it's covered. Homeowners insurance covers a lot more than people may think. Obviously, auto policies cover a lot more than what probably Mr. Geico Insured thought it covered.
CGL policies cover a ton of stuff.
Yeah.
If there's a chance.
Right.
There was a case a few years ago here in Harris County, I think, it might have been in Galveston County, where a company rented a beach house that had a faulty dock. And end of the year party, they're out having cocktails on the patio, and patio collapses and breaks. Guy has real serious injuries, breaks a couple legs, and he sued his company. And the CGL policy for the business covered it. Great news for him.
Yeah. So the lessons are really for everyone that's probably hopefully listening, and that is plaintiff lawyers. You want to plead your case. If you get an answer, you may want to plead your case, write your lawsuit in a way that gets as much coverage as you can get covered. If you're the defendant, you want to make sure you get tendered that to as many people as you can. If you're the defense lawyer, you want to help your client find as many applicable policies. And then the other thing too, and this is kind of insurance 101, is even if the insurance company's gut response is we're not on the hook, under, I think, the old doctrine of the 8 corners rule, which I think has been tweaked a little bit recently, but big picture is they still have to provide a coverage unless, meaning defense, not coverage, but they have a duty to defend the case unless they do a wholesale, you're not covered.
Correct.
And so that can benefit you. Obviously, defense costs can be expensive. And then a lot of times that will, if you're in a settlement posture, the insurance company may throw in more money rather than have to pay for defending it for a long time. So big picture is look at your insurance policies, are very, very important. Good.
So there's that. I've got a couple of questions and a couple of comments. The first one would be, I love the idea that this plaintiff's lawyer was thinking creatively and went out and got this Geico policy on the hook. I mean, that cracks me up. And it doesn't just crack me up. It seems like it falls within the purview of the policy. I'm fully expecting that you're going to see a bill in the legislature next session where they're going to say TDC is now defining use as, by TDC I mean TDI, Texas Department of Insurance, may now define use of a vehicle as non-sexual contact or something like that.
Right.
This is not going to survive very long. It's going to be an anomaly. But I love the idea that there's a lawyer out there pleading it that way.
This is in Missouri, by the way. So
Missouri.
yeah. So
Well,
for anyone interested in possibly passing on HPV,
Yeah,
at least your insurance company probably isn't on the hook yet in Texas.
Well, then that leads me to a different question of caveat emptor. What does caveat emptor mean?
Buyer beware.
That's right. Buyer beware. So my question is, if you're having sex in Missouri, did you not think you were going to get HPV at some point? Has anybody not seen that TV show Ozark or not been to Missouri?
That's true. I mean, actually, that getting HPV may have been one of the lower bad
Right.
outcomes
Right.
out of that whole thing.
Of like the lung cancer or the chronic depression or ending up looking like Sarah Huckabee Sanders, who, by the way, is not from Missouri but is from Arkansas. Like, seems like HPV was pretty low on the list of stuff that could go wrong.
Yeah, well, it did, and it seems that that person will be compensated.
Let me ask a quick question, though, before we move on.
Mm-hmm.
That raises for me a question about common carriers. Hotels, mass transit, buses, Uber. If you contracted an STD at a hotel, I mean, you know what I mean? Like,
Yeah,
I mean, it opens up like a kind of a really broad question about the end and beginning of liability. Clearly, so there are lawsuits pending right now against folks that basically hotels where people go to do all kinds of like
yes, quite a few.
implicated with human trafficking and stuff like that.
Yep.
So my question would be, if folks can sue Geico for a consensual act that leads to HPV, I mean, I'm really curious, like where the
Well,
where are the bumpers on that, you know?
Yeah, but I got to reframe it differently. So Geico was not accused of giving the HPV.
Sure,
The insured, the driver
obviously.
was, and he was the one that was found liable. And then the question was, does Geico have to pick up the freight for that, for what he did?
And my question is directly analogous.
Yeah.
The Four Seasons or the Hilton or the Hyatt, they've got insurance that covers injuries sustained on the property.
So the question, there'd have to be some independent negligence or allegation again, somehow they did it.
Yeah.
Other than just the fact they furnish a very romantic experience for people.
I don't know about romantic, Peter, but it's at least a flat surface.
Yeah. All right.
It's a totally interesting case, and
if we kept talking about it, we would probably get in trouble. So we'll move on to our next topic. All right. This one, while we're on kind of risque topics,
Give me all the risque,
this is
Peter.
pretty recent. This is in my neck of the woods in Austin. A couple filed suit against vacation rental giant VRBO, or Verbo, as I think they like to be called now, and the homeowner, after the couple went into the homeowner's house that they rented through the VRBO platform and found some cameras located in secret places in the bedroom and the bathroom. So, and apparently this was reported to the criminal authorities. This person was prosecuted. He had done it before. So, that is not the first time this has happened. Won't be the last time.
Sure.
VRBO and Airbnb and those kind of companies are
So
very.
is the question, is VRBO and Airbnb liable for that?
That's the question. That's what at least some lawyer in Austin and his clients are alleging. I have my views, but go ahead.
Well, I was going to say, if you go back to the first thing we talked about, right, which was the situation where an employee had murdered someone while on company time.
Mm-hmm.
So I think that all comes down to your question about VRBO and Airbnb comes down to what level of control did those commercial entities exert over the listing of this property, right? If I'm VRBO and Airbnb, I'm arguing, hey, man, I provide a service on the internet to connect renters with rentees, lessors with lessees. That's it. That's all I do.
Mm-hmm.
However, if if you, and by the way, I haven't used Airbnb or VRBO or any of those sites in a while. If you get to a situation where the question is, how much control do they exert and how many representations do they make for things like safety and cleanliness to their customers? And if they've made any representations along those lines to obviously bolster their sales, then they could be potentially liable for it. But again, it gets back to this question of how far do we take an intentional tort and spread that liability over third parties? And I think it's what it's going to come down to is how much control does Airbnb or any of these entities exert over what warranties do they make about safety? And what do they tell their folks about what has to be done to keep the place safe? And it sounds cut and dried. It sounds black and white. But so I've got a friend who owns several ski houses, Breckenridge, Vermont, a handful of other places. And if his, what is it, like the rail on his patio isn't a certain height, he cannot list it.
Right.
If the plumbing isn't up to a certain standard, he can't list it. If he doesn't have a valid annual inspection for his pool and spa, he can't list it.
If he has a bunch of cameras in the bathroom, can he, or is it kind of a gray area on that?
It depends, I suppose, what the community standards are for that place. I kid. Obviously, that's never acceptable. And it sounds crazy, like you shouldn't have to list that. My guess is, if I have to guess, you've got to go down a pretty long kind of rabbit trail of intentional torts to set up cameras and film people doing all kinds of stuff. So my guess is that ultimately the listing agent won't be held liable, but geez, what do I know?
Two thoughts. What are damages? Right? If this person just saw it, I mean, how, like, mental anguish, but you didn't know he was looking at your naked pictures, if he was, until you found out, right?
There's a lot of ways that I could go with this.
I'm just identifying an issue. I'm not saying, I'm sure those people were very upset about it. I'm just looking at it as the lawyer.
So you're exactly right. And it really is kind of really granular, right? It really depends on the plaintiff. If the plaintiff is a woman, if the plaintiff is a child, man, those damages are serious and significant. If those damages are related to like a middle-aged slob who's got 4 or 5 kids and like anybody that wants to see him without clothes on, like, again, caveat emptor, nobody needs to see that.
But it's just mental anguish though, right?
So more than likely, well, you could have some past medical bills.
Yeah.
If you went and saw a psychiatrist. But yeah, it's largely mental anguish. But that is not to diminish the importance of mental anguish damages.
No, I'm not saying that. I'm just saying that's my point though. If you didn't know about it, then
you didn't know about it at the time.
How can you have anguish?
I don't know. I don't know that I 100% agree with that.
No, I'm asking. I'm not saying I agree with it or not. I'm just asking the rhetorical.
Like, I'm trying to imagine if one of my daughters or a female relative came to me and said, "I didn't know this was happening when it happened, but afterwards I found out that I'd been recorded." And that really elicits kind of an emotional response, and I think it would for a lot of jurors.
No, I'm asking that because that issue came up at my old firm in a case they were handling, and that we kind of roundtabled these things. Everyone needs to be taking the devil's advocate position to roundtable. Okay, the second thing though is, okay, we talked. You brought up the scenario. If you have an employee that commits an assault, and the argument is they're outside the course and scopes, and we're not responsible for it. In a lot of ways, plaintiff lawyers get around that. Is they'll allege negligent hiring, supervision, management, training, et cetera.
100%.
Well, in this case, if you go, all right, then I'm going to do that same thing with VRBO. I'm going to allege negligent management, or like once you kind of stake out and start to control what they can do, that's when you start having a duty. Now, here's a problem. What is the cause of action called negligent infliction of emotional distress?
Well, that does not exist.
That's right. So that would be my concern as the plaintiff lawyer, is figuring out how to navigate that. What is your cause of action? Because if it's negligence and your only damage is emotional distress, how do you get around that? There's not a touching. No one's, I mean, the cause of action against the perpetrator would be in some invasion of privacy.
The reality is this is going to be an area where our law, which we will all agree the law is inherently conservative. The law is inherently reactive, right? We don't invent new crimes to prosecute new behavior. We rely on old statutes. In fact, we're still, in a lot of state legislatures, we're still fighting about the idea of, is it okay to codify something as a hate crime, even though we know that the purpose of a hate crime is different than the actual offense, which is usually vandalism or something stupid. But I think you've pointed out something which is, I don't want to say obvious, but lawyers are going to have to get real creative in how they plead stuff like this, because legislatures clearly are not going to be out leading the pack. That's not really their job, right? They're largely reactive to who votes for them. It's clear something wrong has been done, but let me make this suggestion, Peter, which is a very practical one. If you are suing someone who owns a vacation property, there might be sufficient assets there that you don't really need to be all that concerned about Airbnb or all these other things unless the property is like super mortgaged up. That's why I think these cases are interesting. Why I'd love to, if anybody's got one, call me up. I'd love to chat about it, because if somebody's got a vacation house or multiple vacation properties that they can afford to lease and rent and install all kinds of sophisticated recording communication, all kinds of sophisticated video cameras in, I'd love to sue those jokers, right? More than likely, they got all kinds of assets that are not exempt, and in Texas, you can go after.
Good point.
So I think it's kind of a fun way to think about the limits of the law. But the reality is I've had several cases where somebody's called me up describing an intentional tort, and I put my lawyer hat on and I think, how am I going to find someone viable to sue? And then I realize, well, these guys all own ranches. They all own houses on Town Lake in Austin. They all own houses down in Galveston. And I will sue them, and their lawyers will call me, which is usually a brother-in-law, and they'll say, look, you're trying to squeeze blood out of a turnip. And I'll say, how many vacation houses do you own? Because I'm on Facebook right now, and I see your brother-in-law is, he splits his time between Florida and Galveston. I'm just going to take one of those houses. Why don't you come up with a good reason to settle this case? And I think that might apply in some of these Airbnb situations.
No, good thought. They don't need VRBO in the case, and they very well may not have them in the case very long if they're only asserting a negligent infliction of emotional distress. So, but good news is for the lawyer, they got we read about it, so it served that purpose. And look, we talked about this a lot on that story about some of the verdicts. A lot of what you do in law is to hopefully force some change for the good.
Sure.
And if that lawsuit and being reported, even if it doesn't go anywhere against VRBO, forces them and other companies to figure out a way to deter this kind of conduct, make sure it doesn't happen. I know of one in Austin that's a niche, smaller one, and I can promise you they will make sure that kind of stuff doesn't happen. So it goes to our other themes about a company gets bigger. Some of their controls don't always stay in place.
With what's happening.
And that company, VRBO, has been very successful. I use them all the time. I'm a very pleased customer. Fortunately, I mean, I fall in the category of.
Is that because you've called a lot of video?
Yeah, I was going to say, if they want to video me, I'm not, whatever. I'm not going to hurt my feelings.
That sounds horrible.
Yeah, I just don't really care. So, but anyhow, they're a good company. Maybe they grew too much, kind of got some controls out of whack and need to get them back in place. And I'm sure they will, because I think it's probably a well-run company. So
is there a way to test for those video cameras? Like, is there any way to figure that out?
I mean, don't you watch NCIS friends would.
So,
you know,
Peter, I assumed that this podcast would be like a mixture of like NCIS New York and NCIS Miami. So I'm assuming that we've got some sort of technical advisors somewhere
oh yeah,
who are going to help us figure that
yeah.
out. I know.
You sweep it, right? I mean,
just
don't
sweep
you
it.
always sweep your house for
Look,
bugs?
every time I come home, I test for bugs. I've got a big purple dark light. I test for saliva, semen, whatever might be there. We test the vegetables for freshness with a black light. But I feel like our technical staff here has got to be able to help that issue, both for us personally and corporately.
Okay, well, we'll look at that. We'll look at that in the break. Otherwise, we'll conclude this topic and move on to the next topic.
All right. I want to take a 5-minute break.
Yeah, let's take a quick